The next case to come before the court is David Schierbaum, the Ohio Board Department of Education. Each party will have up to 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time for rebuttal, please let me know as I'll be keeping track of the time. Arguments are being recorded, so please introduce yourselves behind the podium, stay behind the podium, keep your voices up. You should not use the names of children or minors. During your argument, you can refer to those folks by their initials or generic terms, like the child. The judges have read your briefs and we're ready to proceed when you are, and I would just ask appellant if he would like to reserve time.
Yes, Your Honor, I would like to reserve 5 minutes for rebuttal.
Very well. Then you may proceed when you are ready.
Thank you very much. If it may please the court, I'm John Oberholzer. I'm here on behalf of the appellant, David Schierbaum, who is contesting a decision by the Ohio Department of Education. The facts in this case are a little complex, but of importance is that the appellant, Mr. Schierbaum, was an assistant volleyball coach at Gilmore Academy High School, and when he was in that position, he was terminated because of conduct that was determined by the school not to be appropriate for a coach. After that was over, sometime a few months later, he applied in 2018 for a permit. I don't remember the exact name off the top of my head, but it's a permit that allows a non-teacher to be a coach in the public school system of Ohio. That application was filed, and pursuant to that application, testimony was taken, and the Board of administrative officer hearing the matter denied the permit, and on the basis of the testimony, which was extensive, all of which went back to the incident where he was involved in Gilmore Academy as a coach. But at any extent, the permit was denied, and in addition, it was the decision was that David Schierbaum would not be able to apply for any kind of a permit with the Department of Education for the rest of his life. And so we've raised three arguments of error, but the essence of this whole thing is the appellant applied for a permit and was rejected, but worse than that, he got a decision that said he could not apply ever again. And that's to a great extent what we're attacking. It's one thing to turn down his license, but then to do something that affects him for the rest of his life when they're not even granting the license to begin with, we would say is wrong. So the assignments of error we have raised have attempted to get at that because of the position the state is in. They have a huge presumption of
your client was pro se before the trial court, as I recall. Did he
Yes.
raise the procedural issues in his brief, or just argue the facts of the reason for his denial of a permit?
I think in the trial court, he just basically said the Board of Education was wrong. No, I don't, and that's a huge problem. I mean, by not being pro se in trial court, I don't know that he effectively raised the issue about the fact that the termination was for the rest of his
If he didn't raise those, are we able to address them now with the court of appeal at the appellate level?
I'm sorry.
If he didn't raise those in the trial court, can we address them at the appellate level?
Well, I think you can if you accept our arguments. Our argument is that the whole thing should have been moved for a couple of reasons. One, it took them almost 3 years to have the hearing to begin with, and the permit that he requested was for 2018. So the simplest way for the Board of Education to get rid of this is just say goodbye. There's no permit. It's on too long. That's our first assignment of error. That's how to get rid of this. And yes, I agree that it does not prevent the appellant from applying again if he wants to, and maybe he should be allowed to, because as time goes on, people do change, and he may be able to submit evidence to indicate that there's nothing wrong with him getting a permit to be a coach, if you wish. The incidents that occurred, by the way, never led to any criminal charges of any kind. The alleged victim, if you wish, did not feel there was anything untoward that happened, or parents didn't feel that. I will, for the sake of argument of this appeal, will say that my client did not certainly use a lot of good sense, because it's obvious the administration of Gilmore Academy was very concerned about his activities. But at any extent, I would argue very strenuously that the Department of Education should not have banned him for life. I guess they have the authority to do it. To answer your question, he did not raise it, but I think it's, the court certainly could have addressed it. It's there. He's challenging the whole decision. Secondly, we have raised an argument based on the fact that the conduct occurred before the application was being sought, and so we would argue that all of that evidence has no direct bearing on that application. And then third, and the state does the same as we do, we spend a lot of time arguing the facts. I'm not going to go over those in front of this court to any great extent, except to say they were originated by presumably another student, and the people that were involved in the actual incident or incidents did not feel they were untoward or anything out of line. And again, we would say to this court that the lifetime ban is the part of this that we feel is the most objectionable. His permit should have just been dismissed, period. There should not have been the tag on top of it that there's a lifetime prohibition. Doesn't mean he should be granted a license in the future, but he should have the opportunity to apply, and I think if there's mitigation circumstances, he should certainly be allowed to raise them. As it is now, he can't even apply. Thank you very much. I believe I reserved 5 minutes.
You did. You'll have your full 5 minutes on rebuttal.
Thank you.
May it please the court, my name is Caitlin Ketchmer, and I represent Appellee, the Ohio Board and Department of Education in this matter. Appellee respectfully requests this court overrule Mr. Schierbaum's assignment of errors and affirm the Medina County Court of Common Pleas judgment affirming the resolution of the State Board of Education. The standard of review for this matter is abuse of discretion. Mr. Schierbaum cannot show that the lower court abused its discretion because the evidence concerning his unbecoming conduct was proven by a preponderance of reliable, probative, and substantial evidence and in accordance with law. The trial court applied the correct standard of review and specifically cited that an agency's finding of facts are presumed to be correct and must be deferred to by a reviewing court unless the court determines that the agency's findings are internally inconsistent, impeached by the evidence of a prior inconsistent statement, rest upon improper inference, or otherwise unsupported.
Counsel, you can present your argument any way you want to, but I'm very concerned over the procedural issues here. So could I ask you a couple questions
Sure.
about that? Yeah, I was just wondering, The appellant is alleging that this is moot because my understanding is because he applied for a specific permit for a school year or years, and by the time the hearing came about and a ruling was made, the board could not have granted the permit anyway because it was past time.
So it is my position, not the department's position, that Mr. Schierbaum has waived those arguments. He did not bring them in front of the trial court. He also did not bring them up during the administrative appeal. Yes, he was pro se at the time, but that was his right to do so, and it's not properly brought before this court.
But can't you raise mootness at any point? Once it becomes moot, I mean, you can raise it at any point, it's moot.
It also is nonsensical to do that though, because he could apply for a permit at any point if he wasn't barred to do so. So saying when the application was applied for, I'm not sure is even really that relevant, because the conduct still took place. He did apply for a permit, and the resolution held that that permit should not, that he should not be able to get that permit at any time in the future.
Should not be able to get this particular permit even though it was past the time. And then the board ruled that he should be barred from ever obtaining a permit.
I guess I don't understand what the appellant means by past the time.
Well, and that's why I was asking procedural questions, so I was gonna get into that too.
Sure.
So they apply for a specific time period for a school year to be a coach. I'm sure you don't get a coaching permit for life.
I believe his permit could have been for 3 years.
Okay, for 3 years. And I think what they're alleging, and correct me if, they can correct me when they get up if I'm wrong, but you can correct me if I don't understand this, right? And that is if they're applying for a 3-year period and it takes over the length of the, so let's say it's 17, 18, 19,
Sure.
and the permit decision is not made until 20, then they couldn't issue a permit for 16, 17, 18, and 19 because it's already passed.
I believe you're correct. I could double check that, but I think what is at issue is that the board is also trying to keep him from ever applying for a license, permanently barring him from even applying for a license based on what the hearing officer found to be unbecoming conduct. So I guess I don't understand your question fully, since if it was moot, he could still apply for a license, but the entire point of the board's decision is that to keep him from doing that based on the conduct.
Yeah, and I understand that, so maybe you can walk me through it. He first gets discharged by Gilmore Academy,
Yes.
okay? And after he's discharged from Gilmore Academy, then what happens?
Then there is an investigation by the Office of Professional Conduct, which is confidential as to how long that takes, the process that happens, et cetera. There's then a hearing, there's procedurally in the record, it shows all of the documents he then received. It's what vernacularly referred to as a however letter, scheduling a hearing officer is assigned, the administrative hearing then takes place. There's then a set period of time that I don't know off the top of my head that there is for a recommendation to come out from the hearing officer. The board then can do with that, makes a final decision based on that recommendation.
So the State Board of Education is the entity that conducts the investigation initially?
The Office of Professional Conduct is
Okay.
who conducts the investigation, yes.
Okay, but it's under the auspices of the Board of Education?
Board of Education, yes.
Okay, and then they assign a hearing officer if they think there's,
If they believe there's grounds to move forward. And what could be the outcome of, like, the punishment is a wide variety, from trainings to suspended during the summer to permanently barring somebody from getting a license.
okay, so what was the hearing officer's original recommendation?
I believe the hearing officer's original recommendation was to permanently keep Mr. Schierbaum from having his license.
Okay, so deny the permit. Was this a new permit he was applying for?
I believe he was trying to get the same permit he had previously had, the activity permit,
It was what?
a 3-year activity permit.
Okay. And was that stayed or revoked during dependency investigation?
No, so the office, it's ODEs to protect due process. Teachers, license holders, certificate holders can continue to work the entire time that they are being investigated. It is not until the board makes a determination that a license could be revoked. But the entire intermediary, theoretically, Mr. Schierbaum could have been working, but he was terminated from his job.
So I'm still a little confused. So was his permit recommended to be revoked? And he had
So-
applied for a new one?
I believe so. It can be considered pending in that intermediate time. So,
Okay. That, I think, was what's confusing.
okay,
Thank you.
yes, a permit that is applied for while an investigation is ongoing can be considered pending in that intermediate time.
Thank you.
Yes. Sorry for if that
No,
was
no,
not
no.
explained thoroughly. Mr. Schierbaum brings this matter out of a June 14, 2022 resolution adopted by the State Board of Education, which permanently denied his 3-year activity permit after an administrative hearing. Mr. Schierbaum thereafter appealed that resolution to the Medina County Court of Common Pleas, which found the resolution to be supported by reliable, probative, and substantial evidence and in accordance with Henry's Cafe versus Board of Liquor Control. The board's action in denying Mr. Schierbaum's application and ordering him permanently ineligible to apply for the license, permit, or certificates issued by the State Board of Education was based on him engaging in conduct unbecoming to the teaching profession on or about 2015 through 2016 during his employment as a coach at Gilmore Academy. During this time, he failed to maintain appropriate student-coach boundaries with the student after the school repeatedly instructed him to do so. These incidents included him posting photos with student one at a Cleveland Cavaliers game, with the caption saying "literally my favorite," attending a Justin Bieber concert with the student, sending student one a birthday gorillagram, ordering new volleyball uniforms for only student one, permitting student one to yell and scream at him after a game in front of the team bus where she would not do that with any other coach, conducting extensive stretching and treatment with student one after being asked repeatedly not to do so by the head coach, and attending a Kanye West concert where there was evidence and testimony that they were observed kissing and dancing. When initially confronted by the school of these allegations, Mr. Schierbaum lied and stated in a text message that he was home with his girlfriend the night of the concert. After meeting with school administrators the day afterwards, Mr. Schierbaum then admitted that he was too personal with student one and that he made an error in judgment. Mr. Schierbaum was immediately terminated at that time and asked not to work with Gilmore students. As previously described, the standard of review for this is abuse of discretion. Mr. Schierbaum's first assignment of error, he argues that the trial court did not make a determination as to whether his due process rights were denied due to the requested license having expired before the date of the hearing. It's well settled that issues not raised at the trial court may not be raised for the first time on appeal. Mr. Schierbaum has never made any mootness or due process arguments to the Common Pleas Court, nor has he cited any part of the administrative record where this argument was brought up at the administrative hearing. Mr. Schierbaum has waived these arguments. That is also the case for his second assignment of error when he talks about not being criminally convicted. That also was not brought up at the trial court, and furthermore, it's within the state boards of authority to deny a license and deem an individual permanently ineligible for future license based on misconduct that occurred prior to the license application being submitted under revised code section 3319.311 subsection A1. Mr. Schierbaum's license was not denied under subpart B2, which he does cite to in his brief.
If this court were to find the matter was moot, initial assignment of error number 1, and that would allow him to request that he could at some point in the future have to have another permit to
Okay.
teach, would the issues that occurred in this incident be able to be raised in his new application? Do you know?
I don't know.
Okay, fair enough.
Sorry.
That's okay.
The crux of Mr. Schierbaum's arguments are that the board's order that his application be permanently denied was based upon him engaging in conduct that was unbecoming to the teaching profession when he failed to maintain appropriate student-coach boundaries with the student. The matter is that there's an abundance of evidence in the record to support the board's conclusion that the respondent engaged in a pattern of conduct which exceeded the appropriate boundaries between a student and a coach. It's fully outlined in the briefing that the department presented sufficient evidence to support each subpart comprising the allegations of inappropriate boundaries. The evidence clearly showed that Mr. Schierbaum treated student one differently and more favorably than other student athletes and engaged in a very personal relationship with a minor. Despite his role as her coach and in spite of being repeatedly notified and reminded that he had to maintain appropriate boundaries with her. The evidence presented at the administrative hearing and outlined in the briefing demonstrates a blatant disregard for these boundaries. Mr. Schierbaum fails to show how the trial court committed an abuse of discretion regarding the factual findings of the hearing evidence. The trial court applied the correct standard of review, finding that the facts are presumed to be correct and must be deferred to by the reviewing court, unless the court determined that the agency's findings are inconsistent, impeached by the evidence, or rest upon improper inferences or otherwise unsupported. The trial court also noted that they must give due deference to the hearing officer's resolution of what occurred during these incidents because the hearing officer heard the witnesses and was able to observe their demeanor and judge their credibility, as well as having the photo and videos to corroborate the witness testimony. Mr. Schierbaum cannot and has not shown that this assessment was not supported by the record and that the trial court was in error. For these reasons, today, and as shown in the briefing, appellee respectfully requests that the court overrule appellant's assignment of errors and affirm the Medina County Court of Common Pleas judgment, affirming the resolution of the State Board of Education. Thank you.
Thank you. You'll have up to 5 minutes.
Thank you very much. I only got, if I may please the court, I'd like to point out a couple things by way of rebuttal. First of all, I would argue very strongly that the matter was moved by the time it came for hearing in front of the, it was a hearing officer who heard this first, and at that time, the 3-year period, at the time of his decision, certainly the 3-year period for the permit would have expired. Secondly, no public school in the state of Ohio can have somebody working for them as a coach without this permit. So to my knowledge, the appellant in this case was not doing anything under the color of that permit while it was pending. So
Well,
again, we would argue that the whole thing should have been moved.
Okay, let me ask you a question in regard to that. So what was the remedy that was actually sought? Was it revocation of his permit?
There's no permit to revoke.
No, I'm talking about when originally they fired him and then then the board did an investigation.
If they wanted to, or if they felt they could, they should have reported it to the Board of Education at that point, and then the Board of Education probably would have considered the revocation of the permit. But none of that happened. Nobody actually knows why, except that, quite frankly, it may have been determined that it was best, considering everything, just to let it stop right there. And our argument is that, okay, nothing happened, so of course he goes out and applies for a new permit. Nothing happens, and then he has this hearing in front of the hearing officer, and it was the hearing officer who initially said that he should be barred from ever applying again based on this evidence. And we would say that that just is incorrect. And the way to handle it was, as I've suggested, is it should just be all considered moot. And if he does reapply, I'm very convinced that all of this is part of that application. I don't think there's anything excluding any of that. And the Board of the Department of Education certainly would consider that in the reapplication.
So
The
counsel,
implication of
counsel,
this
counsel, so your, if the decision had been made during the 3-year period, would your position be different? Could they have made this decision? Could they have said, for life, you can't reapply?
No, my position on that would not change. I think to do this for life is not supported by the evidence.
So the, but does the board, and in certain circumstances, do they have the authority to do that? Is it within their purview to say you can't apply ever again?
Oh, I do, I didn't quote any authority to that effect, but the board does apparently have the authority to ban people for life. Interestingly enough, and I apologize, I didn't recite the authority, but a lot of those cases, the person was actively employed at the time. This man was not, at the time he applied for the permit, and at no time during the permit was he ever employed by any public school system, because he didn't have the permit. And the problem is, he probably will never, ever get a permit from the Ohio Department of Education, irregardless of whether this decision stands or not. But this kind of thing will stay with him in whatever he does. And it isn't just a denial, it's the lifetime ban that is quite to his detriment. And it's done more to generate this appeal than any other factor. So we're saying that the way that the Department of Education should have handled this is just said, this is all moot, goodbye, and dismiss it. And who knows what happens to the future? There never may be another application. I mean, nobody knows. He could apply, he's 42, he could apply 10 years from now, and he might present facts to indicate that he is, whatever you wish, the next coming of some deity, and therefore should be a coach. But to bar him for life, we feel is incorrect, and the way to resolve that is just to say it was all moot. Thank you very much.
Thank you, counsel. Thank you both for your presentations. Court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it's released, and it will also be posted on the Ohio Supreme Court website. And thank you both again for your arguments.
Thank you.